Hello, hello, hello. This is Attorney Mike Grevin coming to you from Chicago as usual. And as you can see, I've got Arty with me. Last second edition. This is fantastic. I saw him in the comments and he was kind enough to come on in. How you doing, Arty?
Pretty good, pretty good. Just got back from work, as a matter of fact. So I was lucky enough to stop in.
Well, that's fantastic. He has no prep on this. I told him it's a sovereign citizen in court, but y'all could have guessed that. All right, we'll get this out of the way. I threw a hissy fit on my my community tab because I can't get the audio levels right. I'm not saying I got the audio levels right, but I just didn't have time to do this video today unless it was live. So that's what I'm doing. And you guys are all so sweet and supportive and all that stuff. So I appreciate it. Because Artie, you probably don't know this, but I'm like, I'm not going to do lives anymore because I'm tired of getting 5,000 messages that the audio's messed up, which it is. It was kind of like Artie's hissy fit with the bad sweater the other night.
Oh yeah, yeah.
Actually, that was fun, and that thing on Blandina was fantastic, by the way.
Well, I mean, I have part 2 coming up, so tonight. So we'll get to see what happens.
And I think we might do something. I'm not sure. I mean, we're not announcing.
I think we could definitely do part 3 because I'm sure you're more versed on his current situation, which is what we'll be getting. I'll probably be getting to in part 3.
All right. Well, let's get this party started and go to the clip. Right. How do I do this now? This way. Let's go.
All right, Mr. Glazier, we have Mr. Scroggins is back from the breakout session. Now, are you ready to go on the record with his cases?
Thank you, Secret Squirrel.
Mr. Glazier, are you there?
Yes. I'm sorry.
Right, we have Mr. Scroggins back. Are you ready to go on the record with him?
Yes, I am, Your Honor.
Okay, we are on the record then in the matter of the people of the state of Michigan versus Levi Max Scroggins, found with 21-20635-FH and 21-20636-FH. Today's the date set for arraignment on both of those matters. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir for the people.
Crazy. Just crazy.
John Glazier putting a hand down for Mr. Scroggins, right?
That's right. Ms. Muir, are you there?
Okay, Annie is asking very nicely for you to like, subscribe, and hit the bell notification. Shameless. And if you ignore Annie, you do realize that is considered capital felony treason.
One moment, Mr. Glazier, waiting on a prosecutor.
This is crazy. This is crazy.
Mr. Scroggins, we ask you to remain silent at the moment until we get your arraignment started.
Can I speak to you, Judge?
No, sir, you can't. We have to go through a process of your arraignment, and we need a prosecutor in order to do that. So I'm going to ask you to remain silent right now.
By the way, he's got an attorney.
Is there any way I can speak with Mr. Stevenson? He actually knows what's going on with the status of all of this.
All right.
Yeah, we are mid-court.
Mr. Scroggins, we're here for an arraignment. I need to have a prosecutor here for that, and I'm going to ask you to remain silent until we have a prosecutor here.
This guy's not nearly as fun as this judge I did from Detroit yesterday. That was fantastic.
That was amazing. But I heard that was awesome.
But I mean, he's a good judge. He just doesn't have the brimming personality like that. I left this for a
Ms.
reason.
Muir or Ms. Wise, are either of you there?
I don't blame him. I wouldn't be either.
Mr. Scroggins, I've asked you to remain silent a couple of times now. If you insist on speaking, I'm going to put your microphone on mute.
Is it okay if I get some water?
Go ahead.
Thank you.
Yeah, this guy is just. I don't know why his attorney probably is just tired of him, but he doesn't even try to stop him. He just lets him hang himself.
Sorry about that, Judge.
I just got denied even water in this place. Awesome. This place is unbelievable.
All right, Mr. Scroggins, again, this is the last time before I put you on mute, all right?
Mhm.
Ms. Mayor, would you like to place your appearance on the record?
Stevie Mayor on behalf of the people.
Mr. Glazer.
Your Honor, today's date and time set for arraignment. My client, I asked him whether he wanted to plead guilty or not guilty. He doesn't want to enter any type of plea today. He wants to address the court and ask this matter be dismissed. After that's taken care of, I guess I'd like to address bond.
That is weird to me. The attorney knows that none of that's going to fly, but I think he just says, I'm not having the fight with him.
I think he's just washing his hands of it.
Yeah, I mean, that's of course crazy, but that's what you requested. I'll ask the judge that.
Mm-hmm.
The judge does exactly what you'd think.
Right, well, at this point, if he's refusing to enter a plea, then the court's going to enter a not guilty plea on his behalf.
Okay?
So does that mean that you're working from the bench, Your Honor?
No, it does not. It means that the law requires that a plea be entered, and if the defendant refuses to enter a plea, the court is required to enter a not guilty plea on behalf of the defendant. So that's what I'm going to do.
So you're entering the plea of not guilty then?
Correct.
So you're going to be working from the bench because I'm not entering a plea of not guilty because downstairs they have not done the proper procedures. This case has already been once dismissed and they rebrung it up and then added charges to it. There's a lot to this case that
I just looked at the judge's face. They rebrung it up. I get tired of hearing this. You're working from the bench argument from these people. Like, they're judges. What else are they? That's yes. Their place of work is the bench.
Well, he doesn't have the script right. He's supposed to say you're practicing law from the bench.
Well, yeah, that's the variation. Of course, they're practicing law from the bench. Well, I guess the only thing that would be effective is you'd say you're impartial, you're biased, or something like that. At least Kim Blandino gets that right. I mean, if you're going to accuse him of something that would help.
Well, what they're trying to, I guess that maybe yes is part of it, but I think what a lot of them say is that in a lot of, in a lot of rules of judicial conduct, you're, as a judge, you're not supposed to be also engaging in private practice. Most of the time, they prohibit judges from, sitting judges or long-term judges are prohibited from engaging in a private practice. And so I think that's where also another angle that they're going from. But again, by virtue of entering a plea on their behalf, that's somehow practicing law from the bench. Yeah.
Well, it's what the judge has to do under the statute. That's it.
And the Constitution.
you don't know about, Your Honor.
Well, at the moment, Mr. Scroggins, we're here for an arraignment. That's an opportunity for you to know and understand the charges that have been brought against you. Mr. Glazer, does Mr. Scroggins wish to have his information read?
Levi, you want to have the charges actually read to you, or do you want to waive the reading of those?
I'm not waiving anything, John.
Okay, we'd ask that the charges be read, Your Honor.
I did not waive the preliminary examination downstairs, and they were outside of their 14-day guidelines then. And they continued even after that.
We'd ask the information to be read, Your Honor.
All
Because
right.
there's two separate charges here.
Mr. Scroggins, I'm going
Yes,
to read
sir.
your information right now because that's what you
Okay.
requested. I'm going to ask you to not talk while I'm reading.
Absolutely.
File number 21-20636-FH, State of Michigan, County of Lenawee, the complaining witness says that on the date and at the location described, the defendant, contrary to law, count 1, prisons, bringing contraband into, did bring methamphetamine, a controlled substance, into a correctional facility contrary to MCL 800.281, parent 3, close parent. Felony, 5 years and/or $1,000. Habitual offender notice, fourth offense notice, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about 5/19/2003, he or she was convicted of the offense of attempt police officer assaulting, resisting, or obstructing in violation of MCL 750.8 D1A.
Dude off my screen.
Mr. Scroggins?
I got some dude in my screen. I'm not even looking at the court. Somebody from the Lenawee County Jail all over the screen. I apologize.
I'm going to ask you one more time, Mr. Scroggins, not to interrupt me.
I didn't mean to, Your Honor.
Mm-hmm.
And on or about November 3, 2005, he or she was convicted of the offense of police officer assaulting, resisting, obstructing in violation of MCL 750.81 D1 in the 39th Circuit Court for the Lenawee County, State of Michigan. And on or about 12/17/2012, he or she was convicted of the offense of attempt police officer assaulting, resisting, obstructing in violation of MCL 750.81 D1A in the 2A District Court for Lenawee County, State of Michigan. And on or about 10/17/2019, he or she was convicted of the offense of weapons and munition possession by felon in violation of MCL 750.224F6 in the 39th Circuit Court for Lenawee County, State of Michigan. And on or about 10/17/2018, he or she was convicted of the offense of police officer fleeing 4th degree vehicle code in violation of MCL 257.602A2 in the 39th Circuit Court for the County of Lenawee, State of Michigan. Therefore, the defendant is subject to penalties provided in MCL 769.12. Penalty, life if the primary offense has a penalty of 5 years or more, 15 years or less if primary offense has a penalty under 5 years. Maximum penalty cannot be less than the maximum term for a first conviction. With respect to file number 21-20635-FH, State of Michigan, County of Lenawee, the complaining witness says on the date and at the time at the location described, defendant, contrary to law, count 1, controlled substance, possession of methamphetamine, did knowingly or intentionally possess methamphetamine, contrary to MCL 333.74032BI. Felony, 10 years and or $15,000 unless sentenced to more than 1 year in prison, or shall impose license sanctions pursuant to MCL 333.740A. Second or subsequent offense notice. Although the people are not required to notify the court or defendant of prior convictions that may result in an enhanced sentence, we are voluntarily informing the court. According to our current information, the defendant was previously convicted of violating controlled substance, possession of analogs, MCL 333.74032B, on or about 9/10/2003, and therefore, on conviction, may be subject to an enhanced sentence under MCL 333.7413, parent 1, close parent, felony, 20 years and or $30,000. Count 2, operating license suspended, revoked, or denied. Did operate a motor vehicle upon US 223, a highway, while his or her operator's license was suspended or revoked as prohibited by MCL 257.904, parent 1, close parent, contrary to MCL 257.904, parent 3, close parent, parent A, close parent. misdemeanor, 93 days and/or $500, vehicle immobilization, CMCL 257.904D. Second or subsequent offense notice, take notice that the defendant was previously convicted of violating MCL 257.904
Those are
on or
soft.
about 7/9/2001 in 2A District Court for Lenawee County, Michigan, and on or about 6/9/2005 in 2A District Court for and on or about 10/4/2006 in the state of Alabama, and on or about 11/27/2006 in the state of Alabama, and on or about 2/7/2011 to a district court for Lenawee County, Michigan, and on or about 1/11/2012 to a district court for Lenawee County, Michigan. Therefore, upon conviction, the defendant may be subject to enhanced sentence under MCL 257.904(3)B and vehicle mobilization under MCL 257.904D. Habitual offender, fourth notice, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about 5/19/2003, he or she was convicted of the offense of attempt, police officer, assaulting, resisting, obstructing, in violation of MCL 750.81DA.
This is definitely a timeline.
Into a district court for Lenawee County, state of Michigan, and on or about 11/9/2005, he or she was convicted of the offense of police officer, assaulting, resisting, obstructing in violation of MCL 750.81D1 in the 39th Circuit Court for Lenawee County, state of Michigan, and on or about 12/17/2012, he or she was convicted of the offense of attempt, police officer, assaulting, resisting, obstructing in violation of MCL 750.81D1A in the 2A District Court for Lenawee County, state of Michigan, and on or about 10/17/2019, he or she was convicted of the offense of weapons, ammunition, possession by felon, violation of MCL 750.224F6 in the 39th Circuit Court for Lenawee County, state of Michigan, and on or about 10/17/2018, he or she was convicted of the offense of police officer fleeing 4th degree vehicle code in violation of MCL 257.602A2 in the 39th Circuit Court for Lenawee County, state of Michigan. Therefore, defendant is subject to penalties provided by MCL 769.12. Penalty, life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years.
I don't mean to interrupt you, Judge, but you don't have to read my.
That's my favorite. I know it's a long time.
Yeah,
But-
can we move it along, please, sir?
That all stems from them when they asked, "Do you want to waive reading the charges?" Of course. So this guy knows what the charges are. He knows he's going to be read, War and Peace on this thing. And he's been in the system that long, so he's been to an arraignment. He knows what the charges are, but he refused to waive it. So this is what you get.
Yep.
I just couldn't believe that. And then he waits till the guy's like 90% done and says, "Nah, we don't need to do that."
All right, we're done.
Oh, and the judge is like, no, we've done this. We're going all the way to the end here. He's almost
I
done.
just muted Mr. Scroggins because he has repeatedly interrupted me in the past and not to interrupt me. The maximum penalty cannot be less than the maximum term for a first conviction.
I mean, look at that. He just walks off.
Mm-hmm.
All right, I have finished reading the information. As I've indicated, I have Mr. Scroggins, through his attorney, Mr. Glazer, has indicated that he does not wish to enter the plea. As a result of that, I have entered a plea of not guilty on behalf of Mr. Scroggins.
In your honor, on behalf of the people, the Mr. Scroggins was had both in both cases, had held an exam in both cases, and they've been bound over pursuant to those exams. So the people have filed the information which your honor has just read. We've also filed witness lists in both cases, and prosecutors demand for discovery, and we have served those on defense. So I just wanted to make that clear for the record. Otherwise, the people are fine with this being set for either a pretrial or a trial. However, defense wants to proceed, but there have been offers made in both cases to defense.
Mr. Glazer, have you received the prosecutor's witness list and request for discovery?
Your Honor, I don't know if I have. Let me see. Yes, I have.
I will set this for pretrial on January 5th at 8:15 a.m.
Excuse me, Your Honor, I missed that time.
January 5th at 8:15 a.m. Is there anything else that we need to address today?
My client wanted to address bond, Your Honor.
Oh boy.
Is there any way that I can speak to the judge?
That's up to the judge.
Sounds like a kind of guy shouldn't be let out.
All right, so bond, as I see it, is currently set at $11,000 cash or surety on the 21-20635-FH file, and $1,000 cash or surety on the 21-20636-FH file.
Yes, that's once they're in jail.
So each file's $1,000.
No, the 635 is 11,000. 636 is 1,000.
Okay, so
Cash or surety. So what is he requesting for bond then, Mr. Glazer?
Your Honor, I'd ask for a PR bond on both files. We need to order the transcript. Evidently, there was an exam on these. At this point, I do have some plea offers from the prosecutor, but Mr. Scroggins and I, through our discussion, doesn't seem to want to try to resolve this at all at this point.
I'm sure most of my viewers know this, but a PR bond's personal recognizance bond. So after that laundry list, after he made him read all that, he says, yeah, I think you just let him out, basically. That's what he just said. He doesn't believe it. The defense attorney doesn't think it's going to happen, but that's what he asked.
So it's probably going to end up at trial. From what he was telling me, the basis of his motions, I would probably need the transcript anyway. So it's obviously going to have to be put out till we get the transcripts. And I guess I'd ask for a PR bond. It's a whole lot easier if Mr. Scroggins can come into my office and talk to me. The amount of, looking at the amount of meth that's alleged to have been possessed here, it was 0.057, and it was almost a year ago, Your Honor, that this
Exactly.
Actually, I think it's almost exactly a year that this was alleged to have happened. So I'd ask for a PR bond.
Prosecutor solid.
Your Honor, I would join in Mr. Glazer's request for the transcript in this case, although I think upon bind over, that is automatically requested by this court of district court, and that district court has to comply with that request within a certain time frame. So it's not like we're looking at lengthy delays in getting that transcript. However, we are looking at delays as insofar as we cannot set trials right now in circuit court. So I would be asking for a pretrial date, which you already gave us in January, so that we can reassess whether we can get a trial date soon or not. However, I do think PR bond is entirely too low. In the one case with $1,000 bond, I think that's more than reasonable. Mr. Scroggins had an exam in both cases and heard the evidence against him. And the court, although it was a lower court, heard the evidence against him. Mr. Scroggins has been bound over as a habitual fourth offender and facing a 20-year charge on the possession of methamphetamine, regardless of the amount. It is an intentional possession of methamphetamine with a habitual fourth offense. That's a very serious charge that does not comport with a PR bond, in my opinion. So I'd ask the bond to leave, or the court to leave bond as is.
May I address the court?
Oh, please.
Mr. Glazer, you have any objection to Mr. Scroggins addressing the court directly?
I don't have any objection. Mr. Scroggins, you got to understand everything you're saying is recorded and becomes a part of the record.
That's fine.
No.
As I previously stated in front of the judge, I have yet to speak to my father. He's still missing. He's 77 years old. His caregiver that he's been taking care of, she's passed away a couple weeks prior to me getting here. Still don't know where he's at. The one other person that I have been in contact with outside of my mother, I don't know what has happened to her. She's just completely fell off, just disappeared. I know that her friend her actually sister that she lives with, sister-in-law that she stays with, she's been in and out of the hospital with COVID. Like I said, my dad's 77 years old. I don't know where he's at. Nobody seems to be able to locate him. I hope he's okay. You know, I have people staying at my house. I've tried to get the officers here to contact the police and send them to my property. They won't do that. You know, I have, you know, nobody out there basically to look for my dad, to get whoever's trying to get in and out of my property, off my property. I have no reason to leave this place. I have been here my whole life as far as all that goes. I didn't mean to interrupt you earlier. It was just I didn't know you were going to read my whole entire record. I was going to save you a little bit of time there. I apologize you had to go through all that. Yeah, I have no intentions on running. I have nowhere to run to. Like I said, my father is definitely missing in action. When I had last been at my father's residence where he is taking care of Laura Wilkerson is her name. The power of attorney over her property and everything came and took in his bed, his TV off the wall, his recliner. They were just picking the whole house apart. And they've served him with eviction papers on top of...
I'm sorry, he just dropped a token, which takes me back to who's our guy, Ryan Alton, who always drops a token. And here's just my thought: if you think token's a word, you're going to jail. That's your next destination. I don't know why; it's just a grammatical error, but that one sends you to jail.
Just taking everything that they possibly can, picking the place apart. And my dad he didn't want to create no problems with anything. He just let them do what they were doing. And I was there creating a log for him so that he wasn't being taken advantage of. I've already spoken with Mr. Stevenson about all of this stuff. I mean, I have the deed to my property. I don't give a shit. I'll put that up, or, you know, I can put that up if that's what you need as far as liability that I'll show up at court or something. I'm not, I mean, my house is worth right around $100,000. I don't really, you know what I mean? No. My main concern is finding my father and locating him and making sure he's okay. And
you buying this, Arty? He's just a concerned son. I'm just like, you know, when he was around and there was a, you know, he never had anything to do it. Well, I don't know, but I doubt that he was like over there, you know, mowing his lawn and whatnot. But here's what he decides to go with.
You know, trying to get some of my affairs in order. It wasn't like this was a planned event, you know. And this case has already been dismissed once before, last year when I was in here, and then they released me then, and then now it's been reissued, and they added charges to it, and then now I have a bunch of contempt of court to a charge I don't even know, I've never heard of in my life. It's over here somewhere. Right?
I don't have.
Showing a stack of your contempt of courts is not a good give me a PR bond argument.
Yeah, I know.
Just saying, you know.
Time for you this morning to review all of your other cases. So you can address this specific case, and I'm giving you an opportunity to do that. At this point, what I'm going to do is take the request for a bond reduction under advisement, and I'll issue a written opinion.
Issue what? I missed it.
I'll issue a written opinion. You'll find out later today or tomorrow what I'm going to do.
I appreciate your time. If you would please talk with Mr. Stevenson. I appreciate your time.
I don't know who Mr. Stevenson is.
I can't have you talk with Mr. Stevenson right now, Mr. Scroggins. He needs to be present to hear the other cases that are going to be called. So at this point, you can tell the officer that you are done in this court for today.
Right. I was just referring to when you get ready to do your written opinion to speak with Mr. Stevenson.
Isn't that nice? The defendant's giving the judge pointers on what he should do before he issues his opinion.
Oh yeah.
Oh, that's rich.
Thank you.
Thank you, Your Honor.
Is it okay if I speak with John before I go?
One second, Mr. Scroggins. I'll put you in a breakout room, Mr. Glazier.
Thank you, Your Honor.
Here at Law Talk, we like to have. Well, there you have it. I just thought that guy was interesting. Another soft sit, you know.
I mean, yeah, but he kind of gave it all up pretty quickly, though. I mean, he didn't really put up much of a fight.
Well, when he asked him, like, do you want me to read the charges? I mean, the guy's been charged, so he's been arraigned like 20 times. He knows what the drill is. This isn't the first arraignment he's been through, and he doesn't waive that. But and then he just keeps talking. His attorney just thought I can't do anything about this.
Mm-hmm.
Because I would have been barging in saying shut up.
Yeah, I think honestly,
I mean, I don't have that scenario, but what I have him at counsel table next to me, and I give him the firm squeeze of the arm, like you do to a little kid.
Mm-hmm.
That's my way of telling my client it's time to close it. You know.
Yeah.
I don't need to do it much, but that's my method. Like all right. Well, thank you for coming by. So, what's going on? You've got part 2 coming of Kim Blandino.
Part 2 at 7:00. So
today?
So in about 20 minutes. Yeah.
Oh, get out of here! Thanks for coming by, everybody. I appreciate it.
Thank you for having me. I'll see you guys.
Bye.
Bye.